next speaker will be Graham Berry. He has been given 3 minutes by Gary Scharf and 3 minutes by Patricia Curtis. Graham Berry from Los Angeles. Good morning, sir.
Good morning, ladies and gentlemen, both on the board and the audience and across the world who are watching on the video cameras far away in Sweden and Russia. Last week I pled with this board to rework and clarify this ordinance and its application at the Scientology compound before unlawful arrests were made, and they have been. Ordinance 884 does not pass constitutional muster. It is vague, ambiguous, and unenforceable because there have been critical changes made to the San Diego ordinance that the county relies upon for its legitimacy here. Section 3 of the definitions section of the Riverside Ordinance differs significantly from the San Diego Ordinance. It adds 3 definitions, clearly designed to apply to the Scientology premises. Sidewalk space. Everyone knows there's none at Gold Base. Then there's a definition of street, which is defined arguably to include the very space that the Scientology attorney, the board's counsel, and several board members have said was available for picketing, the very area near the guardhouse and opposite, which is where last week's arrests were made. If Catherine Fraser speaks here again today, I ask you to question her on these 3 arrests. A definition of targeted dwelling is also added to the Riverside County Ordinance. Now, Section 4 is really where the material changes are made, because the San Diego Ordinance restricts targeted picketing to 300 feet from the targeted dwelling. The Riverside Ordinance restricts targeted picketing to 30 feet from the property line on which the targeted dwelling is located. And then you have Section 5, which adds a whole series of additional penalties, clearly designed and directed at people like Keith Henson, who picketed Gold Base for an entire summer, was arrested, convicted, and imprisoned for 6 months for misdemeanor terrorism and interfering with the practice of a religion for mentioning the possibility of a Tom Cruise missile arriving at Gold Base. These are material differences, and they cause the vagueness problem now being experienced. Last Tuesday morning, as you have heard, in contradiction of the representations made to this board, people were arrested by sheriff's deputies already waiting at that location when the picketers arrived.
But they were not arrested on this ordinance. This ordinance hadn't taken effect yet. They were arrested for trespassing.
If you're going to interrupt me, either stop the clock or perhaps give me my question.
Let's stick to the facts, shall we?
That is not a fact. They were arrested for trespassing on an area covered by this ordinance, and I trust that the time is off now, sir, because you're eating into my 9 minutes.
I will give you enough time.
Because you have encouraged Ms. Fraser and the Scientologists to act as though they're making arrests under this ordinance. You have given them the green light for that conduct. Now,
sir, if anybody trespasses on any residential property in this county, they have a right to make a citizen's arrest, and they have a right to call the police or the sheriff.
With the time still off, Your Honour, this is clearly public property. The area from one curb to the other curb in a straight line is public property. And that is the line on which the arrests were made, parallel in line with the curb.
If your assertions are correct, you have due process, you can go to court, you can prove that, and have any charges reversed, correct?
And that is because of vagueness caused by this resolution, which has caused these people additional and expense to validate their civil rights, which have been encroached upon as a result of this ordinance, either in its application or its formulation. Now, can I continue with the time starting again?
Please.
These are material differences. Sorry. Last Saturday, 2 deputies took the exact opposite position on camera and videotaped, which is now available for evidence to the federal court when this matter gets there. Now, the next significant issue is that the public roadway extends 50 feet from the centre lane. When it was a state highway, it proceeded 100 feet from the centre lane. And the public property that people would normally walk on here has been encroached upon by the Scientology enterprise with non-native flowers, with listening devices, with other vegetation, with sprinklers and pieces of concrete saying this is trespassing. It is irrelevant that the public land has been encroached upon by Scientology. The people are still entitled to picket on that land and to walk on that verge, even though the Scientologists have covered it with flowers, vegetation, listening devices, and water. It is a traditional public forum in fact, as well as in law. And where are these 550 supposed residents of Gold Base? Where are they? You've not heard from one. You've heard from Catherine Fraser, the Riverside County Council, yourself, and the attorney for Scientology. Now, what about the non-Scientology residents of Riverside? The only one of those you've heard from is a former deputy sheriff. And I can add that there are deputy sheriffs all over California expressing their outrage on the internet as to what is happening here. Now, why are the local residents not here in support of this ordinance? Probably because it restricts the picketing rights already in place for sex offenders and the like. What is vague and therefore makes the ordinance, as drafted, unenforceable is the vagueness of the property line itself. Here, the Riverside Ordinance does not even clearly provide ample alternative means of communication as the Klein and Frisbee cases require. The law should provide a clear and definite line as to what and what is not permissible, and that is why this ordinance may be found unconstitutional. Now, some of these problems could be resolved if only the county council and the sheriff would meet with representatives of the picketers. In a spirit of cooperation, it could probably be agreed that picketing at Gold Base would be restricted to the entrance to the main gate, the entrance across from the main gate, and the 4 other entrances and exits, and above the 2 pedestrian tunnels that go under the road. When a similar dispute to this arose in the city of Clearwater, another Scientology mecca, the city of Clearwater responded by defining clearly designated areas around Scientology offices and dwellings such as the Fort Harrison Hotel that anti-Scientology crime and abuse picketers could demonstrate in. The law requires you and the sheriff to act in a fair, impartial and equitable manner, such as meeting with all affected groups and not just the Scientology representatives. Now, there is one other matter here, and that is, for the record, an objection to confluences and conflicts of interest which arise from the relationships between the chairman of the board and the Church of Scientology attorney who represents the Scientology enterprise. Those matters have gone into, but for the record, I reassert them. And also for the record, the only injuries and violence at Gold Base or anywhere else in the world have been caused by the Scientologists. One instance of 3 of them dogpiling, hog-tying, and injuring a person picketing on the property on October 26, which resulted, again, in a citizen's arrest. And there's going to be civil litigation against Gold Base and its staffers for that and last week's arrests. If Catherine Fraser speaks to you today, I ask you to question her as to those arrests and why the water sprinklers were turned on the protesters as soon as they started walking beside that road last Saturday. Thank you.
Thank you, sir. And could you also talk about conflicts of interest?
Sure. Thank you. I would just like to point out that the definition for targeted picketing in this ordinance is verbatim the definition that is from the San Diego County ordinance, and that was upheld in the Klein decision. And the Klein case is a Ninth Circuit case that upheld targeted picketing ordinances. And in that case, it further cites to Thornburg versus Austin and the Brunel case. as being acceptable targeted picketing ordinances. And in both those cases, the courts upheld a distance of 50 feet from the targeted residence's property line and upheld that as the constitutional regulation of picketing activity. This ordinance is even narrower than the Klein, ordinance, San Diego County ordinance upheld in Klein, and the Thornburg and Brunel ordinances. It only regulates up to 30 feet from the property line, and it accepts the sidewalk area across the street from the targeted residence. I don't believe that this is an issue that the First Amendment challenge would be successful in that matter. Thank you.
Thank you, ma'am. Julie